First District Court of Appeals, 9th session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Hey, good afternoon, everyone. Welcome to the First District Court of Appeal. We have 4 cases on our docket today. We will take a approximately 10-minute break after the first case to have a coffee break with the lawyers. So we'll have that break between the first and second case. So we'll hear argument now in Blue One versus Gulf Power Company, 1D20-2143. Counsel, you ready? Have you reserved any time?
Yes, I'd like to reserve 5 minutes for rebuttal.
Okay, thank you.
Good afternoon. May it please the court. My name is Mike Tomkowitz, and I'm here on behalf of Blue One LLC, the appellant and property owner in this matter. I have sitting with me Ms. Ashley Lucas, my partner. We're here today because the proceeding below, the trial court denied Blue One's request for non-monetary benefit attorney's fees because it relied on inadmissible evidence that the condemning authority would not use the easement as expressly written, and because it deemed Blue One's valuation hypothetical and somewhat speculative. This case is important for a few reasons. First, RFP Partnership, which is a case that we cite in our briefs, was decided in 2005. That court lamented that there was little case law explaining non-monetary benefit fees and what constituted a non-monetary benefit. Since 2005, not much has changed. My review of the case law, the First District Court of Appeals has not substantively analyzed this matter or issued any opinions. We cite many first DCA opinions in other parts of the brief, but with respect to establishing a non-monetary benefit, I can find none.
Well, let me ask you this. There's this easement, and Gulf Power wanted to use it for electrical lines, which are there, have always been there. But then this pipeline issue came up in the context of an offer for judgment under the statute, 73.032. Is that correct?
Correct.
Okay, so that statute says that when you make an offer of judgment, if you want to have a condition, you have to make available to the defendant the construction plans, if any, for the project on which the offer is based, correct?
Correct.
Okay, so the sole operation of that statute is to condition the scope of the offer, correct?
It is to promote settlement between the parties, but yes, the requirement to attach construction plans is designed to let the property owner know what the offer is based on. How can they consider an offer of judgment if they don't know the scope of the taking? If there are no plans attached to the offer of judgment, then the property owner has to look at the offer of judgment and consider it to be the worst possible scenario under the terms of whatever the taking is.
So let me ask you this. If the offer is accepted and the scope of plans is limited to only electrical lines, does that bind the offeror? Meaning, is that a legally enforceable restriction here on Gulf Power?
Correct.
To not ever use that easement for pipeline?
They can use it, but there's consequences now. So what they've done is they've bound them to those plans. If they say, look, here's $1.2 million, we're only going to use it as an electrical transmission line easement. We look at that and we say, okay, well, our claim was $6.5 million, but you're offering us 1.2 and you're saying you're not going to use it for above ground pipelines, which means that we can now cross that easement and reliably develop it. Great, we will take your offer, $1.2 million. If Gulf Power tomorrow or the next day, 10 years from now, 100 years from now, decides, you know what, we've got an easement, it says we can have above ground pipelines, we're going to go ahead and do that. They start building above ground pipelines in the easement area. Y River Farms instructs, which was confirmed by Trailer Ranch, that the property owner then gets to reopen the matter and assert additional damages, saying, look, you've breached what you said here. You gave me this deal. You framed the severance damages. I accepted an amount of money that was based on that, and now you're doing something different. So we're going to reopen the eminent domain matter, and now I'm going to assert the damages that are associated with your expansion of use. And so,
Well, isn't that when the attorney's fees would be incurred at that point? Versus...
I think this is the stickiest issue of the whole thing, but it's important, and we briefed it, but basically there's a monetary benefit fee based on measuring the first offer to the result. In this case, it was $88,000 to $1.28 million. If they do that and they give us an offer of judgment that restricts their use, our monetary benefit is measured still between that benefit. We no longer get a benefit in the follow-up case. So when they come in and they do above-ground pipelines, it becomes a supplemental procedure under 73092 that would be awarded hourly fees instead of a monetary benefit formula, because there would be no first offer in that scenario.
But is it your argument that the attorney's fees incurred in negotiations and litigation, all that leading up to the offer that was then accepted, that those, you're trying to recover those, that's what this is about, right?
Yes.
Okay. Those have been incurred, and it basically boxed in Gulf Power to the point that they were willing to concede and just give up the pipeline. That's your argument.
Right, but the public policy behind why the non-monetary benefit fee should be paid, they no longer have to pay the severance. So they're off the hook for the majority of our severance damage claim because they've now bound themselves to electrical transmission line easements. But they're a condemning authority. And more than that, they're a private company that wields the power of condemnation, the power of the sovereign. And Canal Authority versus Miller and Trailer Ranch make clear that condemning authorities should only take the rights that they need.
Well, counsel, let me, on that point, I think you were counsel from the beginning of the case, including when the taking complaint was originally filed.
Yes, sir.
Right? And you didn't state any opposition to the scope of the taking order, right?
We had, the client, before engaging us, had tried to negotiate the terms of the easement, had tried to restrict it to the exact result that we ultimately achieved twice, not just once. That's undisputed in the record. By the time that it got to the taking, we basically told them, look, if they want it, they're going to get it. That sometimes we can get some favor with them if we cooperate with them on the taking, as opposed to trying to fight them tooth and nail to change the terms of it. It's a very low bar, as you can review. White River Farms is the best case out there, because that basically says, look, if you're a condemning authority and you come in and you say, I have legal necessity to take these rights, you don't even have to have construction plans. You can just go in there and say, I have an engineering need, I'm going to be able to do this, I'm going to build above ground pipelines in it, and you don't have to have any plans in it. So that's a tough bar for the property owner to come in and say, look, they're not going to use it for pipeline rights. That's so.
Right, but then it doesn't seem appropriate to then complain that the public policy should be to limit a condemning authority to just what they need if you give up your defense, or if the statute doesn't even allow for you to make that kind of defense at the front end. I mean, I just don't understand. You come in the back end and say, well, they overtook, when at the front end you said nothing in opposition to the order of taking.
Well, and that's a great point, because I want to turn it around. Why didn't the condemning authority work with the property owner from the outset, when the property owner approached him multiple times and asked for the narrow restriction to be added into the easement language? Whose obligation is it to work with the person? I believe that the condemning authority, wielding the power of the sovereign, has a higher obligation to cooperate and work with property owners who they're forcibly taking their property. They're not giving them a choice. They didn't want this. My clients were developers. They're using that big tract of land to create a mixed-use marina residential community. And I put pictures in the brief so you can see the site plans, and there's a bunch of testimony on that. But they went to them. They knew that the easement was expiring in 2012. And in 2008 and one other time, they went to them and said, look, I know that this easement's expiring. We're okay with you putting in the electrical transmission lines, but I want to make sure that I can access my property. I want to protect the investment-backed expectations that I had when I started doing this project. And so will you please work with me? And they emphatically said no. They basically said, we're taking a standard transmission line easement. We're going to need these rights, and that's what it's going to be. And so I'm not sure why the court would impose an obligation on the property owner to fight tooth and nail every step of the way. We tried. We asked them. They didn't want to do it. They wanted to take what they took, and they were recalcitrant in that. And it wasn't until we put in front of them a severance damage number of approximately $6.5 million that now all of a sudden Gulf Power, on the eve of trial, 2 months before trial, after 5 years of litigation, decided, you know what, let's make an offer of judgment and try to restrict the scope of this so that maybe we can get this thing done. Why is it our obligation to try to fight the taking to do that? Why is it not the condemning authority's obligation to try to work it out with the property owner any step of the way? I don't think there's any evidence in the record that the condemning authority reached out to us and we said, no, we won't talk to you.
Right, but it's the law firm that wants to get paid additional money for the non-monetary value being added. And so what is, aside from hiring experts or appraisers and that kind of stuff and putting the number in front of Gulf Power, what else did the
Yeah.
fund do to provide an additional benefit to the client?
And that's a great question, too. I've gotten this before. I've done a number of these. The question judges always want to ask is, how do we justify this large attorney's fee that we're going to now award you? And that's the difference in the benefit-based statute. In 1994, the legislature abandoned a quantum merit hours sort of analysis. And I was back here in 2019 arguing in front of Judge Makar about a non-monetary benefit award, and I was saying, look, my benefit fee is going to be 1/6 of the fees that I incurred on this matter. We had incurred $600,000 in time. Condemning authority had incurred $900,000 in attorney's fee time, and my monetary benefit fee was $120,000. The court upheld the monetary benefit formula there. Sometimes it works out, sometimes it doesn't. But the legislature decided to divorce itself from this concept of how hard did you work to get it, and they said, we're going to look at what you achieved, the benefit and the value of the benefit to the client. And that's how this changed. And so sometimes it's great, and sometimes it's not. And it's tough to be an eminent domain practitioner because you have to navigate how that all works. If this turns out the way it's supposed to, it'll be a better result, and maybe it'll make up for the case in 2019 where we lost. So that's basically the strengths and weaknesses of the monetary benefit formula. So basically, to establish a non-monetary benefit, you have to look at two things. One, RFP partnership is my favorite case to look at an analysis and a framework for whether a non-monetary benefit's been achieved, despite the fact that the court found that there was no non-monetary benefit achieved in that matter. They basically found that whatever counsel had achieved, and they had achieved something, it was not a compensable eminent domain damage because it was a damage affecting the property at an interchange, not on the property itself. So
who makes that call? The trial judge, correct?
Which call?
The call you just talked about, that standard.
Whether it's a compensable eminent domain damage?
Correct.
The law does, is what I would tell you. Do we satisfy the elements? Like, is there a legally cognizable claim? Our severance damage claim was legally cognizable. No one would argue with that.
Well,
if it's
and I know you're familiar with the statute, probably well familiar with the statute, but I'm just reading the statute. To the extent such non-monetary benefits are specifically identified by the court, sounds like the court to me, and can within a reasonable degree of certainty be quantified, that sounds like the court has to make this determination on both prongs.
I'm sorry, I didn't mean to cut you.
On both prongs.
Yeah, there are elements, so that I say three, but yes, identifying a benefit is certainly one of them, and that's why the court's order is so instructive on this point, because the court expressly finds that we helped our client. Quote from the order, it is undisputed that by attaching the as-built plans to the offer of judgment, Gulf Power limited its use of the easement and thus framed the severance damages. The court further found that Gulf Power's offer of judgment contained the as-built construction plans resulting in avoidance of the worst-case scenario damages. Accordingly, the court found, quote, Blue One's attorneys undeniably helped their client, end quote. The court finds that there's a benefit in the express words of the order. She just goes on to say I'm not going to award it because of improper evidence. She looks at it and says the evidence shows that they're not going to use it the way that it says. I objected to that multiple times, got a continuing objection, gave her the law on it. The law is settled and very clear. You cannot rely on evidence that benevolent business practice, non-obligatory policies, all that stuff can't be the basis for finding that there's no damage.
Counsel, you have 2 minutes left in your oral argument. You can use it as you want, but you're running out of time.
Thank you, Your Honor. Basically, that's it. You have to find that there was a benefit achieved. Then it has to be by the attributes of counsel. The counsel has to achieve the benefit. And so there's RFT partnership and other cases look at this. When the benefit's included in a settlement agreement, it's legally enforceable as it was in the final judgment here. There's a bunch of cases on that. If it's a reduction in severance damages, DOT versus CNL Income Fund and DOT versus Winter Park Golf Club both show that when you reduce the severance damages, that's a benefit.
Counsel, if you weren't to win on appeal, Is your client on the hook for any of the fees?
No, that's not, the competitive market that eminent domain is, there's a lot of lawyers and there's not as many cases. And so in fee agreements, it's very typical, and I'm not sure I can identify any eminent domain attorney in my practice area that charges the client in the event that the court doesn't award the fees. The agreement is always, we will accept what the court awards. And so
So the firm is actually the party in interest in this appeal? Is that
correct.
is
The,
that right?
the firm is interested in the result, obviously. I don't work for free, so they would obviously like me to bring home attorney's fees to the extent that I can. But the primary error here committed by the court is that it looks at the easement, ignores the express words of it, and says they're not going to use it this way. That's what the testimony shows. And that's prohibited by Smith versus City of Tallahassee, which is a First District Court of Appeals case, Houston, Texas Gas and Oil Company versus Hoffner, and Prebles versus Canal Authority, which is another First DCA case. So I would ask that your court reverse this order and remand it to the trial court for further proceedings consistent with.
Thank you, counsel. You've used up all your time, including rebuttal time, but I'll give you 1 minute for rebuttal. After.
Oh, did I not reserve 5 minutes at the start?
You did, but you ran through it just now.
My apologies.
That's why I gave you a warning, so.
May it please the court, counsel, I'm Charlie Wiggins, and I appear here today on behalf of Gulf Power Company. Gulf Power requests that this court affirm the trial court's denial of Blue One's petition for non-monetary benefit attorney's fees. The trial court heard 2 days of testimony, both from the parties and from their respective experts. She weighed Blue One's evidence. She rendered a 8-page written ruling, findings of fact and conclusions of law. And in that written ruling, she found Blue One's evidence lacking. She was not persuaded that Blue One carried its burden of proof to establish that it was entitled, or that its attorneys were entitled, to non-monetary benefit attorney's fees. This court need not and should not second-guess the trial court's findings of fact in that regard. I submit to the court that the easiest way, perhaps, to analyze the rightfulness or wrongfulness of Judge Costello's rulings is to start with the statute. Both parties agree that the statute at issue is Section 73.0921B, which is found in the eminent domain chapter. That statute is permissive. It says a court may award non-monetary benefit attorney's fees. Unlike for attorney's fees based upon the value of the taking, non-monetary benefit attorney's fees are permissive. And to establish for a party to prove that it is entitled to non-monetary benefit attorney's fees, and that is a tongue twister, I apologize, they've got to jump through a couple hoops. There are a couple prima facie elements that they must prove to the satisfaction of the trial court. First, the party seeking non-monetary benefit attorney's fees has to demonstrate that those non-monetary benefits, whatever they are, were achieved through the efforts of the landowner's, the condemnee's attorney.
Well, let me ask you on that. The scope of the easement was pretty broad at the outset, correct? It included electrical power lines, and then also the pipeline came in at some point.
It includes a wide number of things that are, in the parlance of many of these easements, necessary and convenient to providing electrical
Right, but
energy
the only
to-
existing utility was the electrical. Right?
That's correct, Your
Electrical
Honor.
lines, there's no pipelines.
Well, that's not exactly true, and I apologize. Let me withdraw that. There were certainly facilities for the transmission of electrical energy. There were also some telecommunications facilities that were coterminous on some of these aerial lines. to
Were
my
they cell
knowledge.
towers, or were they just cables, or?
I think they were just aerial lines that were strung on the towers on this easement. Yes, sir.
So Gulf Power, at some point, added in pipelines.
Yes, sir.
Okay. Now, let's just say that I'm the property owner, and I say, I don't want any pipelines because I want to build homes and amenities, and I don't want these pipelines, and I don't have to be able to cross them, I need roadways. So I get lawyers, and I fight back, and I say, get rid of that pipeline easement. I'll get rid of that pipeline easement. I spend a bunch of money on my lawyers. and then on the day before trial, you all do an offer of judgment getting rid of the pipeline. And this all, I mean, I'm trying to make it match here, but it's hypothetical. But haven't my lawyers achieved a non-monetary benefit in that case?
I don't necessarily agree with you, Your Honor, and here's why. When Gulf Power served its offer of judgment, it was very specific as to what it was, and I'm quite confident that this court has addressed the regular civil procedure offers of judgment under Chapter 7 to 68. The offer of judgment in the eminent domain statute is similar but not identical. In the eminent domain statute, we broke down between the principal to be paid, the damages, so to speak, and the attorney's fees. And so if on the day that Blue One accepts that offer of judgment, whatever those terms might be, Blue One is entitled, or their attorneys are entitled, to attorney's fees. In this case, $308,000. We didn't dispute
For how
that.
many years of litigation was that?
Well, opposing
sounds like
counsel
a lot.
characterizes it 5, but there was a companion case which sucked the air out of the room, so to speak, for several years.
All right.
And so if they're entitled to attorney's fees upon that, the acceptance of that offer of judgment, whatever that might be, the fees are already baked into the cake. They haven't done anything. They didn't put together an offer of judgment and send it to my desk for my signature. That's something that Gulf Power did, and so therefore if they're entitled to fees, the fees are the statutory mandatory fees, not the permissive.
Correct, but aren't they getting a non-monetary benefit that they sought at the outset, which was not to have pipelines across that easement?
I don't know if I would agree that there was a non-monetary benefit, but ultimately, if there was, hypothetically speaking, it wasn't due to the efforts of their attorneys. Whatever efforts of their attorneys were, whether they came to fruition and realized in a gain, monetary, meaning the $1.2 million or so, they're entitled to fees on those. We admit that, and we pay those
Why
fees.
did Gulf Power take pipelines off the table?
I don't know if they have been taken off the table, Your Honor. They are.
Well, again, I know in the future, they could use their condemning authority once again and say, there's a judgment, we cannot put pipelines on here, but we'd like to condemn and to put pipelines in, right? You can come back and do that. Your client can, correct?
Yes, Your Honor.
Right, and at that point, we have a whole new set of litigation, valuations, and all that.
Sure.
But at this point in time, isn't there a non-monetary benefit, or at least some benefit, that may be hard to quantify, that they've received by having that taken off the table? I'm not sure why. Why did they take it off the table? Was it purely altruistic?
I think I don't know if I would agree with the characterization that it was taken off the table. It is an undisputed fact, both from Blue One's, the testimony of Blue One's principal, and as found by the court, and as testified to by Gulf Power's corporate representative.
Well, there's no more negotiation about it. It's taken off the table in that sense.
I'm sorry?
There's no more negotiation back and forth. The litigation, you're litigating about the scope of the easement and the value of the taking. At that point, it's taken off the table in the sense that you're saying, we're not going to negotiate on that anymore, we're just not going to pursue it.
Again, I don't know if I would characterize it in that way because, and this is an undisputed fact before the court, the reason we ended up here today is because Gulf Power included with its offer of judgment the as-built plans. The as-built plans do not reflect an above-ground pipeline. Those as-built plans had nothing to do with Blue One's counsel.
But that's my question, going back. What prompted Gulf Power to put that into their offer of judgment? Was it altruistic? They just, we just don't want our community to have ugly pipelines, so we're going to take that out. I mean,
No.
what's the reason?
The reason why the as-built plans accompanied the offer of judgment is because, in Gulf Power's opinion, it was required under the offer of judgment statute.
Well, why isn't the answer that Gulf Power decided they didn't want to pay the $6 million for all of the easement, and instead they just wanted to pay the $1 whatever million for easement minus the pipelines and just wanted to pay for what they already had and put into the future, if they decide to have pipelines, they can pay for it then. Why isn't that the answer to Judge Makar's question? In other words, why isn't the answer Gulf Power made a decision to segregate or sever the quantification of the taking to what you needed now versus what you may need in the future, and put off into the future what you may need until you decide that you need it?
I think your point is well made, Your Honor. In a perfect world, we could have a list of pros and cons on settlement, but on the eve of trial, when people are spending money, when there is a risk of loss, there are a wide variety of factors as to why a party offers a certain amount of money and at what time. And
I mean, do you dispute that Gulf Power ended up making an offer of judgment based on what it valued as the easement that it took to the extent that it needed it, and put off the table for another day the pipeline issue, which, of course, the $6 million presumed worst-case scenario, right, which would include pipelines, and you took that off the table with the offer, which would reduce the cost of the taking and cost for Gulf Power. I don't understand why you're not just saying that in answer to Judge Maker's question.
And the reason why is to attribute some magical significance to the amount of money that Gulf Power offered when Blue One's numbers were X, Gulf Power's numbers were significantly less than the offer of judgment. Trying to meet in the middle and playing armchair psychologist as what we think they might take, I suspect it was more a function of a dollar figure more than any non-monetary benefit or any sequelae of what was in the offer of judgment. It was a dollars and cents issue to get rid of the impending trial, which was going to be on the value of the taking.
But do you deny that the value of the use left for Blue One's property would be lower if you kept the entire easement, including the possibility of running pipelines above the ground where you're basically cutting off the property unless they build a bridge over it, I guess? I mean, do you dispute that the value of the property that they have would be less if you kept the possibility of pipelines being run on the ground over the easement?
I don't know that I necessarily do, and here's why, Your Honor.
Seems like you're afraid of conceding something, and I'm trying to figure out what it is that you're afraid of conceding.
The reason for my answer is this. When we talk about the specter of an above-ground pipeline, we cannot look at that issue without also taking a look at the property rights that existed from the very beginning of the lawsuit. In Gulf Power's petition or complaint filed in 2014, Gulf Power acknowledged and requested that the court afford Blue One a series of correlative rights, including the right to build roads over and across the easement, the right to install its own above-ground and below-ground utilities, including pipelines, and a host of other correlative rights. And so ultimately, those correlative rights, meaning Gulf Power has rights pursuant to the taking, and Blue One certainly retains a lot of rights, were carried forth into the order of taking. They were ultimately carried forth and incorporated into the final judgment entered by Judge Costello. And so if we say, okay, there's the specter of an above-ground pipeline, in light of those correlative rights, that specter becomes nothing more than a boogeyman, meaning it would be difficult, if not impossible, for Gulf Power to build an above-ground pipeline in light of the rights that Blue One retained during the entirety of the litigation. Ultimately, why did the trial court deny Blue One's request for non-monetary?
But then it sounds like the removal of the specter, even if it's a boogeyman, sounds like a non-monetary benefit. That's why I don't understand why you won't, you're unwilling to acknowledge that there is actually a monetary component to this whole thing, that Gulf Power decided, well, we're not going to build a pipeline anytime soon anyway, And if we just put in writing that we're not going to build a pipeline, we can drop that value from 6 million to 1 million because we're paying for just the value of the actual taking that we intend on using.
I think in Gulf Power's perspective, our valuation included a right, meaning the value that we thought we could put in front of the jury, included the right for us to build a pipeline, and we would just hash that out at trial. And so, to the court's point that we should have or could have made that an integral moving part of our offer of judgment is a point well taken. I don't know if it got that scientific, is my answer to that, Your Honor.
Well, if you look at the litigation expense, attorney's fees and costs, two parties are litigating over time. Was it 5+ years? And let's just assume that 90% of that was focused on the pipeline. Okay, so 90% of all the attorney's fees, costs, so forth, experts, all focused pre-trial and getting ready for this hearing. And then at the last minute, you take the pipeline, there's 90% of those fees and costs have been incurred, but that's not a part of the actual award they got. They only got their award here for the electrical line easement. So why shouldn't they get, I mean, it sounds to me like you, meaning Gulf Power, or utility, could have this broad scope of taking, litigate it, run up the costs for years, and then at the last minute, oh, we just want this little sliver. And we don't have to pay them that much, only $1 million and $330,000 in fees. Is that the way it's supposed to work?
Well, ultimately, if, by that logic, Your Honor, the non-monetary benefit attorney's fees didn't accrue until Gulf Power made its offer of judgment and they accepted it. If they thought, meaning if Blue One thought it was so unfair that they should only be compensated for the amount of effort they had put in to date, they shouldn't have accepted the offer of judgment. Let it ride, go to trial, and file whatever post-trial motions if they win or lose. Ultimately, however, I think this court should give dignity to the trial court's findings that, based upon the evidence in front of her, no non-monetary benefit was achieved by the efforts of Blue One's attorneys. In her words, I am not persuaded. I suspect it would be going a bit far afield if this court were to second-guess that finding of fact by Judge Costello. I see that my time is up. I thank you for your attention here today. Thank you.
Thank you for your argument. Counsel, you've got 1 minute.
Apologies for not understanding the time clock. Just wanted to make two brief points. With respect to the subservient rights, the Court of Rights were all, we couldn't use them unless it was consistent with how they were using them. It's right up in the requirements. Provided that the exercise of such right of ingress and egress does not interfere with the safe and efficient construction, maintenance, and operation of the company's facilities and works, we couldn't just go ahead and access it. It wasn't equal footing. There wasn't rights reserved for us. We got the client what they wanted. This is all they wanted from the beginning. Ultimately, the use restriction is there. They have, in the record, said they would not accept the OJ unless that use restriction was there. Condemning authorities should narrowly take property. To allow them to kind of throw something out there, have an overly broad taking, and then come back and decide what rights they truly want at the end of the day is wrong, and this court needs to stop them. Thank you.
Okay, counsel, appreciate your arguments, both of you, and we will be in recess.
All rise.
Please be seated. All right, good afternoon once again. The second case on our calendar for today is Florida Office of Financial Regulation et al. Versus Kimberly Grippa, 21-1357. Ready, counsel?
Good afternoon. May it please the court. My name is Mark Alexander. My partner, Samantha Judici Bertasia, is seated at the counsel table. Together, we represent the three state defendants agencies, the Office of Financial Regulation, or OFR, the Financial Services Commission, or FSC, and the Department of Financial Services, or DFS. Your Honor, I could reserve 2 minutes for rebuttal.
Very good.
If the court will bear with me, I'm going to try to avoid using the acronyms. It makes it longer, but it makes it a little clearer. Rather than OFR, FSC, and DFS, I'm going to call it the Office of Financial Regulation, the Financial Services Commission, and the Department of Financial Services. At the heart of the case is a constitutional issue. You know, at the cornerstone of really all of the case law dealing with the waiver of sovereign immunity is the constitutional concept of separation of powers found in Article 2, Section 3 of the Florida Constitution. And so in order to get at that particular fundamental constitutional issue, I think it's important to start with understanding the governmental operations, the governmental functions that are in play in this case, which starts a bit with understanding what some might call a bit of the Byzantine structure, and getting into a bit of the structure of the state government here.
Well, counsel, pardon me for interrupting, but does that really matter in this case, or any case involving sovereign immunity? Isn't the test not so much the Byzantine structure, it's about whether there's a policy or plan? If we're going to use the two-part analysis or dichotomy, isn't it all about whether that analysis is met?
It's all about yes, it's all about the two-step process that the cases talk about, and the functions of government that you're talking about. And when the courts evaluate those two steps, well, the first step is whether there's a common law duty, and when the courts move to the second step, it typically is an analysis about those functions of government.
So,
Yes.
so if this case was involving the deputy commissioner of financial regulation, the hiring, firing, would it be the same analysis, and there'd be sovereign immunity for the hiring, firing, retention of the
A
deputy?
deputy of the OFR would be hired by the director of OFR, and so it would be a different analysis,
Okay.
yes. The director of the OFR is essentially hired by the governor and his cabinet. And so the Financial Services Commissioner, FSC, the hiring authority here, the primary defendant on the negligent hiring case, let's make no mistake about it, the object of the negligence case is the governor, the attorney general, the chief finance officer, and the commissioner of agriculture. They are the ones acting in their constitutional and statutory authority who are essentially the ones accused of the negligent act. And so the difference, to answer your question, is the cabinet hires the director would hire everybody else.
Why do
And
you use
so-
that term hire? They don't hire the director, they appoint the director. So why do you use the term hire in this context?
That's true. The statute uses the term appoint. Absolutely correct.
Do you think there's a difference between the two?
I suppose, in a legal sense, I'm not sure I see a difference. I suppose the word appoint suggests what this is, which is a political appointment. It's a discretionary act by the senior-most elected officials in the state to determine essentially a policy matter by appointing a particular person.
Right. I mean, does the governor hire the Secretary of State, or does the governor appoint the Secretary of State?
As to
Just
the
as an
Secretary of
example.
State, I don't know.
Or any agency has?
As to the Office of Financial Services here, the OFR, the governor and his cabinet, the four of them together in a deliberative body, the word the statute uses is appoint.
Right.
And so it doesn't use the word hire.
And in other contexts, in similar government setups, sometimes the appointment, I think it's either DEP or FDLE, the appointment is then subject to Senate confirmation. Not here, but I'm just curious why you don't think there's a distinction between hiring and appointment. It seems like seems like an interesting
Well, I'll
difference.
confess, Your Honor, I don't know. The statute uses the word appointment, and so that's the word that the statute uses. And I do think that the question's on point in the sense that we ought to use the terminology that the statute uses. And in this case, it is the word appointment.
And in that respect, then, I mean, why do we even get that far in the analysis to, even talk about commercial carrier or that kind of test? I mean, the test doesn't really seem to fit planning or operational when you're talking about political appointments.
I agree, Your Honor. I think a lot of the cases and a lot of the work, I would think of the courts generally, is in that difficult middle, where there's an ambiguous line, and we're trying to tease out where the line is and which side of the line, where tort law ends and where government begins, and we're trying to tease that out. And so the cases are like highway patrol officers on the side of the road and how they deal with a car crash, or how, a building inspector interacts with the public, and those kinds of cases. In this case, though, Your Honor, I think the question is on point. In this case, the plaintiff in the case is alleging essentially that the senior-most elected officials in the state got it wrong when they made a political appointment. It is
Well,
not
I
subject.
don't see it as being a political appointment. It's obviously a political appointment. It would be no matter what the administration, who the officers are. It's political in that sense. But as I understand it, the complaint is alleging that there is basically a implementation of a policy, or maybe failure to implement the policy, doing the background check and so forth.
I think that the appellee certainly argued that in their brief. However, it is not alleged in their complaint. At the brief at page 9, they do make that kind of statement that the appellates, they talk about the policy-making role, establish the essential requirements in the hiring process, and so forth. However, I direct the court to paragraphs 44, 53, and 59 of the amended complaint, where there are these conclusory allegations about the policies of the department and everything. There are no allegations in the complaint to back up that statement in the brief. And in fact,
But the complaint says the actions of the defendants, this is count 3, in performance of operational functions, i.e. functions that are not necessary to or inherent in policy making or planning, and which were merely secondary decisions as to how existing policies or plans will be implemented.
that's the allegation, yes, and that's repeated in each of the counts.
Mm-hmm.
I would characterize that particular allegation as conclusory, because there are no allegations, there are no facts in the complaint.
Well, then shouldn't it have been dismissed without prejudice to fill in those facts or wait for summary judgment?
Well, first, the allegations aren't made, but then the follow-up question is then, well, maybe the plaintiff ought to have leave to amend. And to further to Judge Tannenbaum's question, I don't think it matters, because even if the governor and his cabinet, in the exercise of their discretion, had established some process by which they're going to exercise their discretion, I mean, certainly senior elected officials get to do that.
They can establish the policy or procedure, right? We would say that is going to be subject to sovereign immunity. They're deciding whether to put the stop sign in or the stop light in. That's just a planning level. But when at the operational level, they implement it in a particular case, say in this case, doesn't that put it outside of that?
Not in this case. In this case, it's more analogous than the example the court gave, is an elected official has discretion to make an appointment. And that elected official, in the exercise of that discretion, establishes a process by which the elected official is going to exercise his or her discretion. The plaintiff's theory here is, as soon as the elected official establishes this process, then that subjects the elected official to a negligence claim if they don't do it right, as opposed to the elected official who doesn't establish a process at all and just exercises discretion somehow is immune from suit. And so the kind of processes we're talking about here are processes that elected officials exercise in their sole and unfettered discretion as senior elected officials. That's the kind of we're not talking about where a stop sign goes. We're talking about the process that the governor, well, and by the way, it would be the process that each of the 4 of them would establish.
Well, why wouldn't the focus be, well, I'm the plaintiff and I'm filing a lawsuit. I don't care why you hired this guy. I don't care what the political machinations were. All I know is that there's a background check that wasn't done. That's the only thing I'm concerned about. Why isn't that an operational level negligence type claim?
It's just that at the core,
I'm not going to ask, I'm sorry to interrupt, but I'm not going to ask, plaintiff's not going to ask questions about, who referred who and all that about the politics and all. But
It's just that at the core, Your Honor, that question is saying the governor should be held at fault. It's subject to a jury verdict because he did or didn't get a background check on somebody.
could it be an action against the agency or to the, and again, just generalities, could it be an action not against the individual, the governor or the cabinet members, but against the agency that was supposed to have done
It's against, in this case, the FSC, which is the commission, and those 4 elected officials are the commissioners.
Right. Well, what if that was dropped out?
I'm sorry?
What if that was dropped out as a defendant, the cabinet?
Well, then, if they were dropped out as a defendant, then the people who allegedly committed the negligence are no longer in the case.
Well, what about OFR and DFS? I'm sorry, I'm using the initials, but.
All right. The Office of Financial Regulation is the employer of, alleged employer of Ms. Grippa, as alleged in count 1, which is not on appeal, under the Florida Civil Rights Act. So the OFR is a proper defendant under the Florida Civil Rights Act on count 1 as the employer with a capital E, as that statute would define an employer. I would suggest that the OFR is the only proper defendant under count 1. The Department of Financial.
But the other counts are against all 3.
The negligence
OFR.
counts are against all of them, yes.
Right. And unlike the FSC, which has the appointment power, the other 2 agencies do not, with respect to Mr. Rubin. Right?
Correct.
So
Yes.
what's your best good faith sovereign immunity argument as to those two agencies? Why do they get sovereign immunity here?
Well, the negligence claim is again because the ultimate decision-making upon which allegedly all of these agencies would be liable, assuming there is liability on all 3 of them, is ultimately the decision by the governor and the other 3 elected officials. And so the question is identifying, frankly, a pleading deficiency in the plaintiff's case, as opposed to a vulnerability in my argument. Because ultimately in the negligence case, I agree those defendants should have been dismissed for that reason. But on a sovereign immunity issue, ultimately the negligent hiring, retention, and supervision claim is directed to the manner in which Mr. Rubin was hired, supervised, and retained by the people who are responsible for doing that, which is the FSC.
Right, but so I can look up in the statute who appoints Mr. Rubin. What I can't find in the statute is how DFS or OFR manage, if at all, the agency, essentially the agency head. Now, that may seem like nonsense, like how could the agency manage their agency head, but is that not an issue of fact or a pleading issue or a failure to state a claim as opposed to a sovereign immunity issue?
Well, I think it's all of those, including the sovereign immunity issue, because the theory of the plaintiff's case and the claim that was sustained by the trial judge was a negligence claim against all 3 of them. I would agree that the other 2 should have been dismissed, but as to sovereign immunity, that theory is as to all 3 of them, and ultimately, even as to all 3 of them, ultimately, the decision maker and the object of the negligence claim is the agency head that appointed Mr. Rubin, and the agency head are the 4 of them collectively.
Mr. Alexander, I had a brief question as following up on the questions of Judge Makar. Assuming you're correct about the FSC, and they're no longer part of this case because they're sovereignly immune, extrapolating off what Judge Tannenbaum just said as well, where within this pleading are we able to say, as a matter of law, based on what's been pleaded in front of us, that these other 2 entities are entitled to sovereign immunity? That's the difficulty I'm having based on the 4 corners of this complaint.
Because as a matter of law, the allegations as to all 3 of the agencies are ultimately, it is the same negligent act as the plaintiff has alleged the same set of negligent acts as to all three agencies. And that negligent act ultimately is the governor and his cabinet. That's the answer to the question. I see, Your Honor, I have about 1 minute left that I can reserve for rebuttal, unless there's a follow-up question.
If Judge Jay would like to follow up, we can add additional time.
Well, and just in line with that, why wouldn't they be given an opportunity, though, to replead as to those other entities, because there's no statutory prohibition I'm aware of saying that those two entities are responsible for the appointment of Mr. Rubin, correct?
The answer is because by statute, the questions illustrate why the plaintiff failed to state a claim as to those other two agencies. Of course, on an interlocutory appeal, we only had only the sovereign immunity issue is subject, but the.
And and that may be my point, and maybe the points of my two esteemed colleagues, Mr. Alexander. It may be that you have a failure to state a cause of action argument, but that's not why we're here. As I know you know, we're here about sovereign immunity, and I just can't divine from this complaint or from the statutory structure how these other two entities are entitled to sovereign immunity. But if that's a question, I'll give you an opportunity to answer it.
I'll wrap that up and then reserve my time. The answer, such as it is that the allegations, regardless of who the defendant is, the allegation is essentially that the governor, the attorney general, the chief finance officer, and the commissioner of agriculture should have gotten it better and got it wrong with their appointment of Mr. Rubin. That's the core of the allegation. And that allegation is in a negligence case, first against the FSC, but that is also the basis of the negligence claim against the other two agencies. And as to that particular nucleus of facts, that particular claim, to the extent that there's a cause of action at all against those other two agencies, it's that cause of action. And that ultimately, even as to those other two agencies, it requires the court to do judicial review into how these senior elected officials went about the hiring of Mr. Rubin.
Okay, thank you, counsel. We ate up all your 2 minutes of rebuttal, and we had an additional minute of question and answer. So we're going to add 3 minutes to both sides.
Thank you, sir.
May it please the court, I'm Rick Johnson, Tallahassee, Florida, for the appellee, Kim Grippa. One of the things that I think we need to do is take a step back and look at what is going on here. It seems to me that the appellants have all their eggs in a basket with a very weak bottom, and that is this distinction between a high executive and a low executive. Now, sovereign immunity law is created in the Florida Constitution, and the waiver of sovereign immunity law is created there, and then the legislature fleshes that out in 768-28 and in a few other places, but for sake of negligence, 768-28. Neither the Constitution nor the statute has ever made a distinction between a high-level official's conduct and a low-level official's conduct. In fact, the first and only time it ever appeared in Florida law is in the one case that the appellants rely on so heavily, which is the Storm case versus Town of Ponce Inlet. And there's no explanation of it. It's just ipsy-dixit. It's just pulled out of thin air. It's a judge-made distinction usurping a legislative function. There needs to be a statutory distinction on high-level official versus low-level official. I think it would require something close to an en banc decision of this court to overturn the decision below, because there's such a substantial body of law that says creation of a position is a planning level function. Filling of the position is operational.
Do you not make a distinction between hiring and appointment?
Pardon me?
Do you not make a distinction between hiring and appointment?
No, I don't see any basis for one. Yeah, I mean, in either case, you have somebody who was without a job yesterday, with a job today. He's got a title today that he didn't have yesterday, got a salary that he didn't have yesterday, comes to work and performs functions that he didn't have yesterday. It just seems to me like a purely semantical sort of thing.
But it's, pardon me for interrupting, but it's a case-by-case determination according to what the cases say. Every case is different. And if you're talking about someone who's being appointed at, say, very high level in state government, doesn't that matter in terms of the analysis? I mean, call it appointment, call it hiring, whatever, but that person is being brought in at the highest level to run an agency. And isn't that where the separation of powers idea in the case law has developed, to say that we don't want the judges getting involved in those high-level appointments unless it's an operational type of
I've been
function.
struggling with that for a few days now since I started preparing. I came into the case late, but I can't find any kind of a textual or even a theoretical basis for.
Well, there's no negligent appointment cause of action, is there?
Well,
Or is there?
Appointment. You know, the sheriff, they use different language in different agencies, and I have sued some sheriff's departments on behalf of clerical people, secretarial people, and they were called appointment. Their hiring was called an appointment. That's just something that happens. If it's an appointment by the sheriff, you can sue. And that doesn't mean that if it's an appointment, you know, I've sued the Secretary of the Department of Corrections. I've sued secretaries of many of these state agencies. They're appointed by the governor. They're even confirmed by the Senate.
But have you sued the governor for negligently appointing one of those secretaries?
Not yet.
I mean, would you sue the Senate as well for negligent confirmation?
Never found it necessary to do that. And nobody's ever raised it.
But my point is, the reason I ask that is we're talking about what it seems like the quintessential executive function, which is the power of appointment. And there's a difference. There's no one privately, there's no one, as far as I know, that privately has the authority to exercise sovereign power and exercise executive power, making an appointment of somebody. They can hire folks, but no one has the power of appointment outside of state government.
Right, and why, though, should that be a basis for immunity from suit?
Well, because the
that
statute
person-
uses the term employee. I mean, that's coming from the statute. It doesn't say appointees or employees or something to that effect. It says, it talks about immunity, acts and omissions of any employee of the agency or subdivision.
Well, sure, it says that, but yeah, I don't understand why that's not semantic, because there are people from the very highest level to the very lowest level that are denominated as appointees. And if the mere terminology was the thing that determined the immunity, then the sheriff's secretary would be immune. The sheriff would be immune for sexual harassment of the secretary. So I don't get where the distinction is coming from.
Well, let me ask you this. There's questions by my colleagues earlier about the Financial Services Commission, which is the cabinet. What if there's a case that says appointment of this individual, Reuben, by that entity that was subject to sovereign immunity? All right, so that defendant is gone here. You're left with the other two. What's your argument as to sovereign immunity as to the remaining two? They're not appointed bodies. They're appointing bodies.
Well, then you're not even getting into this high-level executive thing anymore. You're just in the commercial carrier. At that point, aren't you? You're just, talking about, is it a primary function or a secondary function? You're back to where writing the job description and creating the position is planning level, and filling the position is operational level. Isn't that where you are? And for the supervision, you assume the department. So, it's a dilemma that we get into all the time, but it's really a purely semantical dilemma. It's a distinction without a difference. If we sue the Department of Corrections because the Secretary of the Department of Corrections did something, the Department of Corrections couldn't have stopped him. That just happens to be where he works, so that's who you sue. In much the same way that you sue Amazon if Jeff Bezos does something within the company. There's nobody who could have fired him or who could have done something, but somebody has to be liable. And there's an entity called the employer, and that's what the agency is.
Well, let me ask you this, because I guess we're just at the pleading stage. We just have the amended complaint at this point, correct? So my question focuses in on what is there at this point in time that shows there was a established policy to have checked out Mr. Rubin's background, to have found out all the things that were discovered later?
If I understand it,
There's been no discovery, or has there been discovery?
No,
okay.
yeah.
So-
that all need to happen in discovery. And
So my question is, what is there, what do we know about sitting here today on the face of the complaint about what policies or procedures may exist that may have been violated at the operational level in bringing Mr. Rubin into state government?
Well, we assume that the background check is the main thing, and that there would have needed to be some sort of internal policy and procedure that somebody like Kim Grippa could have used to go through HR to bring Mr. Rubin's conduct up through. There would have been some kind of a bypass to go around him. There would have been a Farragher-Ellerith sort of policy and complaint in place. There would have even sometimes been some monitoring of the staff to see if the conduct, the unlawful conduct was going on, particularly where it was affecting enough people that it might have come to the attention of a reasonable supervisory staff. So those are the sort of things that either were not in place, or if they were in place, were not being enforced, were not being scrutinized, were just not being honored if they existed, and should have existed if they didn't.
Go ahead. We had a question.
What if we were to conclude that the FSC has sovereign immunity, but the other two agencies did not? Are we able to go, on this review, it's an appeal of a non-final order on the basis of a denial of a motion on the basis of sovereign immunity? Are we able to look at the pleading and conclude, well, there's still not an ability to state a cause of action as to the other two, and reverse on that basis, or do we have to only focus on the question of sovereign immunity here in this appeal?
Yeah, I would say that'd be going beyond the scope of what's being appealed. I think that the greatest handicap that we're all under is that there should have been some discovery, and there should have been a motion for summary judgment, and this case should be here on that basis. It shouldn't be here this early. It's not ripe. I mean, it may be technically ripe because there's, obviously a final order of dismissal, and it implicates sovereign immunity, and so it would be eligible, I think, even for an interlocutory appeal. But, it's just that sort of thing where, knowledge is knowing a tomato is a fruit, and wisdom is not putting it in a fruit salad. And, that's, sort of what is happening here, is that we've got a tomato in this fruit salad because, we're here with no discovery. We're here in a situation where a lot of this stuff would have been played out. There would have been depositions taken, and I would be able to answer all the questions that you have.
I didn't fully understand your answer about, Judge Tannenbaum asked about, if the court were to determine that OFR and DFS didn't have sovereign immunity, but that the Financial Services Commission did. It sounded to me like you said that was beyond what is presented in this case, and I didn't quite understand that.
You're saying I'm getting these initials confused. The one with the governor and the cabinet would be immune, and the
FSC.
other...
If they're sovereign immune, but the others aren't, what happens?
Well, it depends on whether we can treat those other two entities as the employer and attribute the offending functions to them. And, that's going back to what we were talking about before, where if the Secretary of Corrections cannot be overruled or regulated or monitored by anybody, can we still sue the Department of Corrections as the defendant? So if the action...
You're confusing me more, because I thought that you have sued them. You have sued all three entities, and now you're...
We have sued all the entities, but you were saying what would happen if the one of them, the governor and the cabinet, were found sovereign immune and the others were not.
Yeah, it sounded to me what you're saying is that we as an appellate court can't reverse as to two and affirm as to one.
You can do anything you want. You're the judges.
Well, that's good to hear.
Yeah. I mean, you're up there in black robes. You can do anything. So, that's not the concern. The concern would be, is there a remedy?
Your Honor, I was going to promise I wouldn't use all four, but I shouldn't do that, I suppose. To respond to a few of the questions, actually completely different questions, but ultimately maybe come to the same place. My comments are based on the complaint that was alleged. And the complaint that was alleged alleges that the governor and his cabinet got it wrong. The plaintiff does not allege any policies, practices, procedures, or internal mechanisms, or any of those kind of operational things. That isn't alleged in the complaint. It's argued in the brief, but it's not in the complaint. And so that's the first. And that then comes to the question about the other two agencies. Because the allegations against all three agencies, as counsel just said, all of these facts are attributable to all the functions and the functions of all three defendants. I think the statement was all of these acts are the same. The question is, what's the negligent act as to these other two agencies? And the answer was, it's the same negligent acts as to all three. So the question is, what would the lawsuit look like against these other two agencies that are not the appointing body? Ultimately, it would look the same. You'd have a negligent hiring. You'd move forward with discovery. That was argued. Who are you going to depose? The hiring authority is the governor and the cabinet.
Yeah, but the governor and cabinet aren't the ones doing the background checks, are they? They're busy folks. It's going to be the agencies that do that type of...
Well, I suppose, but there's no allegation about anything about background checks in the complaint.
Well, no, it says all the defendants failed to fully investigate him or ignored allegations previously made. This is as to all three defendants.
I don't know whether the governor is doing his own background checks, but I would suggest that it doesn't matter, because when these elected officials are appointing senior officials, they have staff who do things. They have internal processes. Perhaps they have their own vetting mechanisms that they put in place. And those kind of vetting mechanisms, one could characterize those as operational. I would characterize those as the high level of government doing its job, which is carrying out the duties of the office of appointing a senior level of person. And even if your fault is with the manner in which the governor's staff or one of these other folks did the vetting, ultimately it's a challenge to the elected official. And that person is the one who has to answer for his or her negligent act. I'd add to all that the body here, too, is a deliberative, collaborative body. So you also have the dynamic between the four of them, and why one of them voted for or against or abstained, and all of that is all part of this discovery that's going to lead to the summary judgment motion that was just articulated. That's all part of the discovery. And I'd conclude with sovereign immunity is about freedom from suit. It's not about freedom from liability such that you can escape liability at the summary judgment level. Sovereign immunity is not having to withstand the lawsuit in the first place. And so to answer the question, and that's the answer as to the DFS. As to those other two agencies, I would say that these allegations against the senior elected officials is ultimately the gravamen of the claim against the other two agencies.
Okay, thank you. We appreciate
Thank
it.
you.
Appreciate your advocacy, both sides. Okay, we'll now turn to the third case on our docket. Everyone okay? All right, the third case we have this afternoon is Gulf Management, Inc. versus Talmadge Wall, 20-3741. Counsel, you prepared? Ready? Please begin. And have you reserved some time?
I'd like to reserve 3 minutes, please.
I'm at 3?
3.
Okay, thank you.
May it please the court? Counsel. My name is Tiffany Hawks, and I represent the appellants, Gulf Management, Inc., doing business as Tampa
Can you
Bay.
talk a little bit closer to the microphone? There you go, it might be.
I represent the appellants, Gulf Management, Inc., doing business as Lexus of Tampa Bay, and Gallagher Bassett Services, Inc. The issues before this court arise from a judge of compensation claims order dated November 30th, 2020, awarding permanent total disability benefits from April 21st, 2020 and continuing. It's the appellant's position that the judge of compensation claims erred in awarding permanent total disability benefits because he misapplied prong 2 and prong 3 of the Blake method that was set forth. The first argument regarding prong 2 is that the consideration would have to require permanent work-related physical restrictions coupled with an exhaustive but unsuccessful job search. The appellee acknowledges that in addressing the sufficiency of an exhaustive job search, this court has provided an opinion in Public Supermarkets versus Redding that says that a claimant's efforts must be reasonable and performed in good faith in light of the relevant circumstances, including physical impairment, age, industrial history, training, education, motivation, work experience, work records, and diligence. There's no dispute.
Don't we have to defer, or shouldn't we defer to the JCC's findings on that? And related to that, the JCC made an express decision to go with the claimant's vocational expert over the employer's vocational expert. So isn't that the JCC's call on that?
No, Your Honor. In this sense, he misapplied the prong 2 because this court has set forth what constitutes a reasonable job search, and the JCC did not consider that case law and did not explain it. He even noted in his order that the failure of the claimant to provide a written history or any type of printed history of a job search was, quote unquote, somewhat curious. In
But
fact,
the JCC also found that the claimant engaged in an exhaustive but unsuccessful job search.
Right, but that's not supported by the evidence that was before the judge of compensation claims, and hence the misapplication. If you look at what the judge found, he found that Mr. Wall he estimated 1.3 to 2.6 contacts per month. He acknowledged that was on the low side, and that's a quote. He never addressed the inconsistency between the trial testimony, where he derived those numbers, and the deposition testimony. The deposition testimony, which was submitted before the court, and he doesn't address the fact that from May 17th to August 27th, Mr. Wall only applied for 5 jobs. That's an average of 0.6 jobs per month.
But you're addressing what the JCC found or didn't find, as opposed to addressing what is the absence of evidence. If you're going to focus on what's missing in the evidence, what do you think should have been in that
Your
wasn't
Honor, I
there?
think they should have considered the fact that in 2019, he only did 1 job search for the entire year. There's no way that that would qualify for a reasonable or exhaustive job search. If to hold to the contrary actually undermines the purpose and intent behind the second prong of the Blake test. I mean, he applied for no jobs in 2020. So that's not competent substantial evidence to support his findings. And he doesn't address why he disregarded the fact. In fact, he said in the order that after the termination from Goody's Fleet, which happened in November of 2018, that the claimant conducted and looked for work without success. That's not factually accurate based upon the evidence. In 2019, he applied for 1 job. That's 0.08 jobs per month if you take that over a year.
But as I look at it, my reading of what the JCC was trying to express is, yeah, we could look at slivers of the person's history. It's like 6 years they looked at, something like that. And some of them may not meet the standard if that's all we were talking about. But if you look at the totality of it, as I understand it, the JCC is saying, look, this guy, he's done all these other searches. He had tried to start his own business. He's actually found some jobs. And so overall, I'm finding, even though there may be these discrete deficiencies in the timeline, that overall the timeline is sufficient in the JCC's view to establish the basis for the TPD.
But I think based upon this court's prior rulings on work search, even though those are in a temporary partial disability setting and not a permanent total disability setting, that the JCC's order does not follow what this court has set forth on what to consider for an exhaustive job search and one that's done in good faith. And I don't think the evidence is there to support the judge's determination to the contrary. If you look in the Romey case, the Couture Fashion versus Romey case, this court said that the minimum evidentiary standards for proof of an adequate and good faith job search should include names of businesses contacted, the type of work sought, the number of contacts made, and the time frame within which the work was sought. That was not here. He admitted he didn't apply for work, and yet the judge found that he did a good faith job search with no applications at all in 2020 and only 1 in 2019. That's not an exhaustive and good faith job search, and that undermines the entire standard that was set forth by this court in the second prong of the Blake, which is whether or not there has been a good faith and exhaustive job search. Job searches in permanent total disability cases should receive stronger scrutiny. This is someone who is asking to be found unable to return to work in a sedentary capacity. Therefore, you shouldn't just accept no job search and find that that is an exhaustive job search. It should be a higher standard in these cases.
What about if you're looking at the statute? So the statute says not able to engage in at least sedentary employment. What happens in a situation where the employee maybe is more likely to work in non-sedentary jobs than in sedentary jobs? What do you make of the statutory provision that sets almost like a floor, treats sedentary employment as if it's a floor, and you have a scenario where the employee actually can do more on his feet?
If they're able to do more or greater than sedentary work, it would be our position that they would not qualify under a strict reading of the statute, which says at least sedentary. So if you can do something greater, then you would not be permanently and totally disabled.
But what if the employee couldn't do sedentary work but could do, I understand it's an abstract concept that somehow sedentary work is considered lower than non-sedentary work. But is that what you're saying, though, as a matter of law, if there's evidence to show that the employee actually is able-bodied enough to work on his feet, so to speak, that's dispositive of the question whether it's PTD?
Yes, that's our position, because at that point, if they can do greater than sedentary work, that means they would fall in a light, medium, or heavy-duty capacity, and they would not qualify under the statute.
Was there any evidence presented at the hearing to establish that fact? That did the vocational expert for the employer opine that he can do greater than sedentary work?
No, they all agreed he was capable of at least sedentary work.
At least sedentary work.
Yes.
But does that factor, the fact that the claimant, can do something greater than sedentary work, does that factor into the type of jobs that person should be looking for when determining whether it's a sufficient search?
It should, because, I'm sorry to interrupt.
No, go ahead.
No, Your Honor, it should, because if they can do greater than sedentary work, that would expand even further the job market availability for jobs for them within any restrictions or limitations they have.
What type of evidence, what would be enough for CSE in this type of scenario? You said obviously you take the position that one search per year is not enough, but what would be the legal principle we'd have to announce to say that that's not enough, but 2, 3 searches a year would be enough? I mean,
No, Your
where do we
Honor,
draw
I
the line?
think that when you're asking to be determined to be permanently and totally disabled, you have to show good faith, which means at least greater than one search per week. I would say at least 5 per week, because you have to show that there's been some effort made. I mean, no searches or one search a year is not sufficient. I mean, there should be some kind of evidence that the claimant has to provide to the court indicating that they have really gone out there and looked for work, and not just work that he wanted to do, but work that was within his restrictions and limitations.
Does it have to be documentary evidence, or can it be verbal testimony of the claimant?
I think it can be verbal testimony from vocational experts. I think that if they're going to give verbal testimony from the injured worker, it would have to be detailed as set forth by this court. The court has considered verbal testimony before in several of the cases we cited in our brief. I think the situation is they can't just come and say, I looked for work and I contacted 5 jobs every week for a year. I think they're going to have to identify what kind of jobs they applied for to make sure were they hiring? Were they available when they applied? Who did they talk to? Were the jobs within their restrictions? I don't think that they can just come in and do a blanket, I looked for work this many times per week, per month, or per year. I think it has to be a higher standard.
Well, yeah, and there seems to be a gray area. We don't have anything to hang our hat on in terms of what's the objective standard. But if someone comes in and testify, well, every week or every weekday I went on the website and looked and I didn't find anything that I could do, or those I did, I reached out to and I didn't get any response, that's not enough?
It's a gray area, and I think, Your Honor, that just saying they looked on the website, a lot of times they can track their history of jobs that they've applied for. They can make a list knowing that they are going to be pursuing a permanent total disability claim, showing that they have actually, who they've contacted, what types of jobs they looked for, whether or not they exist in the labor market. I think that's all significant evidence that should have been provided and was not in this case.
Well, it does say that claimant must have testified to something here, because it says claimant says about 50 to 100. I mean, was there any cross-examination about, well, you said you had 50 to 100, well, can you detail those?
He couldn't provide any details, and he provided no job search at his last deposition. I did ask for him to provide any documentation, and again, the judge noted that it was kind of curious that he was not able to provide it by the time of the final hearing.
It says claimant claims to have written record of his job searches, but claims he has been unable to locate it.
Correct. But he couldn't even remember specific employers, and if, he admitted there was only one in 2018 and there were none in 2020, so even if he had produced records of that job search, it probably would have predated 2019.
Do you think claimant has an obligation to present evidence of some sort of market information, market evidence? I mean, again, going back to the statute for a moment, which doesn't mention vocational searches. It mentions unable to engage in at least sedentary employment within 50-mile radius of the employee's residence. Do you think that the claimant, just taking your CSE argument for a moment, does the claimant have to present some sort of testimony about what the market is around his residence, what's available in terms of jobs, whether he searched for them or not, whether those jobs exist? Anyway, I'll leave it at that.
If the claimant is not able to do it, I think it's their obligation to have a vocational expert provide that testimony. Our vocational expert at the trial did indicate that there were jobs available for him within his permanent restrictions and limitations, including the service drive manager position from which he continued to work from the promotion in December of 2014 up until his termination in July of 2016.
What if the claimant applies for jobs and just is a bad interviewer and doesn't get any of these jobs? Is the claimant still out of luck? What is your take on the exhaustive search? Is it just he has to search for them, or does he have to do a good job of actually getting the job or interviewing, or is it just the availability of the job, whether he applies for it or not?
I think it's establishing, one, that there are jobs available within his restrictions, that he has applied for them, and then who he's contacted so that investigation can be undertaken. Was he refused a job because he was a poor interviewer, which isn't related to the industrial accident, or was he refused a job because of his work restrictions and limitations? It doesn't appear in this case that Mr. Wall was a poor interviewer, because he did secure subsequent employment. And I think it's important for the court to know, in reviewing his subsequent employment, that he lost those jobs or quit those jobs not for reasons related to his restrictions or limitations from this accident. It was because when he applied for Gordon Chevrolet, he started with them in September 2016. At that time when he applied, he did not reveal that he had any prior restrictions or limitations related to an accident. He then went out for surgery in March of 2017. They weren't able to hold his position at that point in time. When he started to do his own business, he testified that he just wasn't able to make it work financially. He only had 3 yearly clients. He had no income. It differs for some of the other cases cited in the briefs, where those claimants actually went off, were self-employed, maintained their employment, and derived income. There was no evidence before the lower tribunal that Mr. Wall made any efforts to really develop any of his self-employment. That's not related to the accident. That's his choice and how he handled that business. When he worked at Palm Harbor Honda, he left, and he indicated on his application for Goody's Fleet Services that the reason he left was because of a long commute and no advancement opportunities. Again, nothing related to the industrial accident or his restrictions. His employment at Goody's Fleet Solutions, which is his last employment, that lasted in 2018 until November 2018, approximately 3 or 4 months. He was terminated because he didn't generate any new leads. Again, not related to the industrial accident or his restrictions. And then after that, he neglected to perform what we consider to be an exhaustive or good faith job search. Moving on, because I know my time is short. Our second argument is under prongs 3 of the Blake test, and it's our position that the judge misinterpreted the misconduct testimony. It wasn't being offered as an affirmative defense, such as you have in a temporary partial disability case. It was being offered solely to show that his restrictions, even at the last in April of 2020, could have been accommodated by the employer, and there was a job that he was capable of doing. With regard to our third argument under the third prong, there were no specific vocational factors that were delineated in the order. You have to delineate the specific vocational factors because that prong requires permanent work-related physical restrictions, while not totally alone disabling, that preclude the claimant from engaging in at least sedentary employment when combined with those vocational factors. There is vague, nonspecific testimony from Ms. Balter, the claimant's vocational expert, but there are no specific vocational factors that were delineated by the judge, and therefore, we respectfully request the court to reverse. And I'll reserve the rest of my time if that's okay for
You have 2
rebuttal.
minutes and
Thank you.
32 seconds.
May it please the court. My name is Nicolette Sambus. I represent Mr. Wall, the appellee in this matter. This is a case about a 53-year-old male who had a traumatic work-related injury, a rather serious injury resulting in over a 30% permanent impairment rating for his upper extremity. This is his dominant upper extremity. He was involved in 4 or 5 surgeries during the course of his treatment from the date of the industrial accident to the present. It's a CSE case. This is a case where the judge of compensation claims made competent substantial evidence findings based on the facts of the case. It is a case where there's no question of law. Strictly, the brief is only questioning the facts of the case. And when there's only questions of facts, it's CSE. So it's an easy math equation. It's competent substantial evidence plus credibility equals the judge's award of permanent total disability benefits. And whose role is it to determine credibility? It's only the judge's. The judge determined that based on Mr. Wall's presentation, his history, his credibility never even being questioned by the employer carrier, throughout the whole record, you'll see that there's no question of Mr. Wall's credibility. He is a credible individual who testified honestly during all of his depositions. He was motivated, as the judge determined, to find work. He obtained work. He continued to work for the employer. But I think what's missed a lot in the employer carrier's brief and throughout their argument is the progressive worsening of his condition. His arm continually got worse. This is clear in all the record, in all the medical testimony. It's clear in the vocational expert testimony. Even the employer carrier's own vocational expert had to agree. It wasn't something where Mr. Wall had the same work restrictions when he was working for Lexus to the present when he actually applied for permanent total disability benefits. This is a case where he was working, his arm continued to get worse. He was ultimately let go from Lexus in 2016, but even at that point in time, his work restrictions were no lifting over 20 pounds.
But he didn't lose his job at Goodies because of his arm.
He didn't.
Right.
With Goodies, he was terminated after 4 months because he wasn't able to continue. He didn't have a client base, right?
Which has nothing to do with his arm.
Well, I would disagree. I don't believe that necessarily plays a role. It's, as throughout the testimony of the claimant, his credibility was never questioned. He indicated that he can't keep up with everybody else. He's not able in that industry, given his limitations, given his restriction that's confirmed by Dr. Stone, that he has to limit the type, capacity, volume of work that he does. This is his right upper extremity. He can't lift over 4 pounds with it, and even if he's using it with his left hand, it's only to be a helper. So
Is there any evidence that he was unable to stand for extended periods of time, work at a counter somewhere, at a cash register? I mean, was there anything that addressed his inability to have some sort of standing job?
No, Your Honor, there's no restriction on walking or standing, and I'm not here arguing that there is. But I am here to indicate that the work restrictions are less than sedentary, and that's clear by both vocational experts.
But how can it be less than sedentary if no one disputes that he's capable of walking around? There's plenty of physical activities he actually can do, including walking, weeding, riding a lawnmower, fishing, driving a car for a couple hours, swimming, all of which the JCC credited him with as being candid for admitting to all that.
Right.
And I have a question about that in a moment. But with all of that, how can anyone credibly say on the record that he is less than sedentary when, as a matter of, I mean, it just seems undisputed that he is not sedentary.
I understand your position. The evidence is in the vocational testimony. I'm not a vocational expert. I relied on Ms. Balter's testimony at the lower level, and that's exactly what the judge of compensation claims did. The judge of compensation claims is the one who assesses the expert testimony. The expert testimony here that he accepted versus the expert testimony from Mr. Roberts for the employer carrier was that jobs that have less than 4-pound work restrictions are less than sedentary, because sedentary, according to the occupational titles, Dictionary of Occupational Titles, indicates that you have to lift over 10 pounds for it to be sedentary. So that's why you get the less than sedentary qualification. She did a transferable skills analysis. She found that there were 4 types of jobs that the claimant could potentially participate in, but then given his work experience, given the limitations on volume, capacity, type of work that he could do, that he was a poor candidate for any of those positions. This is a case where the judge found not one of the 3 prongs, but 2 of the 3 prongs applied in order for Mr. Wall to be entitled to permanent total disability benefits. I agree that there is a job search element, and then the judge found further and or in the alternative that he still met the 3rd prong. So it's not just that the job search qualifications, that the exhaustive job search, where he assessed the credibility of the claimant and found that given he was motivated, he found alternative employment, he actually participated in trying to make his own business work but was unsuccessful with that, that all equaled to a exhaustive good faith job search. There's no case law that indicates a minimum job search. In fact, the cases from this court have indicated that there is no minimum. This is an entirely factual determination that needs to be made by the judge of compensation claims, and that's exactly what was done in this case. I know, Your Honor, you had another question about his activities of daily living.
So why do you think the JCC credited him with candor for admitting to all the physical activity that he engages in, including throwing a baseball to his son and all the other things that I listed?
Well, Your Honor, at the lower level, there are a plethora of cases where where the judges of compensation claims are confronted with potentially less than credible witnesses or claimants who indicate that maybe they are limiting their abilities in an effort to possibly further their case. In this situation, Mr. Wall was honest. He's a family man. Why should he be prejudiced or sanctioned or in any way inhibited from pursuing his workers' compensation benefits and what he's due because he's trying to live a life with his family? Why should he limit and stay at home and further debilitate his condition, further, make himself atrophy in his arm? And there's also a psychological component that needs to be considered too. I mean, he is receiving ongoing treatment from a psychiatric standpoint as well.
Wasn't that waived, though? I mean, I thought the focus at the hearing was on the physical aspect and not the psychiatric.
You're absolutely right. It is, but my point is that with activities of daily living, yes, he mowed his lawn. Yes, he had good days and bad days. Yes, he tried to be a father to his son and coached his son's baseball team. But also the testimony in the record, and it's clear, is also that was from 2019. There's no testimony that he was doing that even after his 5th surgery. His 5th surgery, which took his work restrictions not from a 20-pound lifting restriction, but to a 4-pound lifting restriction with further limitations on his ability to participate in a high volume, high capacity, repetitive typing, repetitive movements, overhead activities with his dominant upper extremity. So those activities of daily living, in the record is clear that it's before his last surgery, before he was ultimately placed at maximum medical improvement, and before the request for permanent total disability benefits were awarded. But also, he shouldn't be prejudiced for being able to try to take care of his family.
Well, is it possible that the JCC credited him with candor because that type of evidence actually cuts against his claim that he's unable to work because of his physical limitations?
I don't believe it cuts against his case. I believe that it further goes to his credibility, and that goes down to the the issue of this case, the theme of it, is credibility. The credibility that establishes the competent substantial evidence that the judge of compensation claims relied on. The judge was making that indication. When he said that he found the claimant to be, I'm trying to find the exact quote that I wrote down, but found him to be credible because he testified willingly and openly about his activities, that goes to his candor, that goes to his honesty, that goes to his credibility. That goes to the basis of why the judge felt that he was a motivated claimant that was trying to get back to work, but just was frustrated with the chronic pain, the constant need for repeat surgeries. He had 5 surgeries. This is a significant injury, and this isn't one where you have a 1 to 2% permanent impairment rating that was assessed. He was assessed a 31% impairment rating for his right upper extremity. And I think that that's very important when it goes to the third prong of the Blake test, which is the work restrictions, the severely limiting work restrictions that even the employer carer's vocational expert had to agree were extremely limiting, and then plus the vocational limitations. When you add those two together for Mr. Wall, it equals permanent total disability benefits. The judge of compensation claims has the ability to weigh the evidence, to consider one expert over the other. He found Ms. Balter's testimony to be, the quote is, the ultimate opinion is both more realistic and more objective than Mr. Roberts' testimony. And the judge of compensation claims does exactly what he's supposed to do, exactly what this court has indicated in the White decision and the Chevrolet decision about that they have to say that the expert's testimony that they're not going to accept was not persuasive. And that's the judge did. The judge outlined exactly why he was rejecting Mr. Roberts' testimony versus Ms. Balter's testimony in the instances where they differed. But there were instances where they were the same, where Mr. Roberts even testified that the evidence that the claimant actually obtained employment, tried to participate in self-employment, is evidence of a job search. It's not that there was no job search. And that even goes into play with the second prong of this case.
But was there any evidence that that he searched beyond? I mean, the evidence is that he searched Indeed and Compass and Monster based on automotive sales and service. Is there any evidence that he searched beyond that or matched the search to what his own vocational expert was saying that he could do or what his doctor said he could do?
So that's what that's what Ms. Balter testified to. She testified that.
Well, she testified as to what he told her that his search was. She didn't testify as to the search that she conducted, as in fact she admitted that she didn't do any market search for this case. So was there any evidence beyond what he said and his own description was as he went on the websites and searched for automotive jobs, service and sales? Is there any evidence beyond that he conducted as to the searches that he did?
You're talking about the industry, I'm sorry, Your Honor, or are you talking about like
Any job.
documentation?
Any job. Like in terms, he searched for a small sliver of the market based on what he did in the past, but that's not what the statute expects him to do. The statute expects him it has to be unavailability of at least sedentary work that he can do within 50 miles in the metro, the metro Tampa area.
Right. That goes into play with the vocational qualification. So you're asking if he searched for a McDonald's job versus just strictly looking in the car industry. Well, that goes to the third prong of Blake. Yes, the statute says inability to participate in sedentary employment within a 50-mile radius of your home. That's what the statute says. Then this court decided in Blake, which is the precedent case, which is what PTD is based on these days, is those three-prong elements of Blake. So you go to the three-prong elements of Blake, and the second prong of Blake even applies, where it's an exhaustive job search coupled with work restrictions that are causally related to the industrial accident. So it doesn't say that you have to look for jobs that you've never participated in your life. He knows how to sorry.
Why not?
Why does the statute not say that? Why does Blake
the
not?
statute doesn't speak in terms of it. There's nowhere in the statute that requires that he only look or say that it's satisfactory to only look in what he did in the past.
You're right, it doesn't say that.
Okay.
But the vocational qualifications, his transferable skills, what he's done in the past is in the automotive industry. That's what his resume is. Why is somebody going to hire him at a bank if he's never had any bank experience? He's 50.
Did he apply?
No, but he's 50.
So we don't know.
We don't know that.
Right.
You're right.
And he didn't testify that he searched for anything in the market other than the automotive sales and service. I guess on the theory that he's only required to look in his previous industry.
I'm not saying he's only required to do that. I'm saying that the judge of compensation claims assessed his credibility and found that he was participating in a motivated job search. The judge of compensation claims is the one who assesses the credibility. The question of whether it's appropriate for him to search outside of his injury or if it's appropriate for him to apply for a bank job or a McDonald's job, that's a question of fact. That's a question of credibility. That's a question of, was Mr. Wall actively participating in a search for employment? And the answer was yes. With his work restrictions, with his everything that he's gone through, the fact that he actually found jobs that were within his work restrictions, but then his work restrictions even became more severe. So he continued to try. He tried. He had more surgeries. He tried. He was successful in getting jobs, but then lost the jobs. He had another surgery, lost the job. His work restrictions now go from 20 pounds to 4 pounds to even having an inability to on volume, capacity, and type of work. So it's not where he had these open-ended restrictions where he can do things in other areas of other jobs that probably don't require transferable skills. He has severely limiting work restrictions, and according to the testimony, with those work restrictions, you have to apply your transferable skills. And the vocational testimony that was accepted, the credibility of the vocational witness, is the competent substantial evidence that the judge of compensation claims relied on in finding that the vocational skills plus the work restrictions mean he equals permanent total disability benefits.
Is exhaustive search subjective or an objective test?
Well, I believe it could be both. It's a question of fact. This court has determined on several prior decisions that it's a question of fact.
Sure, it's a question of fact, but it depends on the perspective. So the JCC, if you say it's subjective, then I guess you're right, that it's okay for the JCC to just take an employee at his word. If he does a search a week or a search a month, that may be good enough. That doesn't sound exhaustive to me, but if I guess subjectively you would say it's enough for the JCC to ask the claimant, did you do an exhaustive search? Yes, I did. And that would be sufficient. An objective test, seems to me, would require some evidence about the market and show that within the universe of available jobs, he searched, use the term exhaustively, till there was nothing left to search for and was unable to work because of his physical limitations. That's the difference. So where do you come down on it?
I side on the case. I side on the decision of this court's prior decisions. It's based on the totality of the circumstances. So what does totality of the circumstances mean? Totality means you consider the objective evidence, yes, but you consider the subjective nature of a claimant. You can't hold it to as the employer carrier indicated, a 5 minimum job search a week, because what if we're dealing with an individual hypothetically that has no education, who can't read? How are they to be held to the same standard if they can't use a computer? And in this day and age, especially with the pandemic, where you can't go in and apply for a job, are they to be held at the same exact standard as an individual who has a college-level education, who knows how to operate a computer, who can operate Monster.com? It's not a cut-and-dry decision, and that's why the power of this decision is with the judge of compensation claims and to determine credibility, and to assess whether, based on the totality of the circumstances, based on the claimant's age, based on his ability to do so with the job search, what qualifies under that second prong. So it's important that the focus remain on credibility that was determined by the judge of compensation claims, which supports the competent substantial evidence, that the judge used to award PTD benefits under the second prong of Blake, but also further and alternatively under the third prong of Blake. So, Your Honor, in closing, I would just add that it seems to me that the employer carrier's points on appeal are really similar to the arguments that were made in the Manning decision, and that was the 1996 decision, where it's rather self-defeating under the appellate review. It is, they're saying they have competent substantial evidence to support their position that permanent total should not be awarded. Well, that's not the standard. The standard is there was competent substantial evidence that the judge of compensation claims used to assess the credibility, not only of the vocational expert, but also of the claimant. So we would ask that you affirm the lower court's decision and award of permanent total disability benefits.
Thank you, counsel.
Addressing what was raised during appellee's argument, Mr. Wall admitted to using the affected extremity for which he has permanent restrictions for doing yard work, lifting weights repetitively, routinely, coaching his baseball son's team.
What was the time frame for those activities?
Well, Your Honor, that's a good question. I was going to bring that up because the judge of compensation claims found in his order that he started decompensating after the March 28, 2017 surgery. All of these activities took place after that surgery. These activities included kayaking, canoeing, zip lining, snorkeling, fishing, swimming, boating, playing basketball.
Can you link all that up to what the employee's burden of proof is in this particular instance? Are you saying that those facts cut against the his claim that he's less than sedentary? I mean, the JCC chose to go with the vocational expert. So link up those facts to how it's relevant and why you would win.
Okay, Your Honor, I can do that. If he was decompensating as found by the judge, then it didn't impact his extracurricular activities at all. He never came in and said, I used to do these type of activities. I no longer can do these because of the industrial accident, my pain or work restrictions related to that. In fact, Mr. Roberts testified that when you consider these type of activities, it goes against a finding that someone is less than sedentary. It shows that they have a greater ability than the restrictions they're assigned.
Even though the definition of sedentary work is 10 pounds or more?
Yes. He said that when you consider these type of activities and using that extremity, it would be greater than sedentary.
Do you think the word sedentary or sedentary employment in the statute has the same or different meaning than what the occupational guide says?
We follow the occupational guide when defining sedentary, and we question the vocational rehabilitation experts and doctors and work comp.
So if you have a vocational expert that says, well, he's less than sedentary because he's under 10 pounds, doesn't that actually support the claimant's position?
No, Your Honor, because our vocational expert pointed out that that is considered with regard to both extremities. He only has restrictions related to the right extremity. There are no restrictions to the left extremity. So when you consider both extremities, our vocational expert indicated he was more than capable of doing greater than sedentary work. And I think that's significant in this case. And even though the judge found him refreshing, it did not really take into consideration the impact of his ability to secure employment. Again, there were no vocational factors that were delineated in the order, and the evidence doesn't show, because under prong 3, you have to not only take the restrictions, but it has to be combined with vocational factors, and there were none that were delineated. And I
Thank you,
believe
counsel.
I'm out of time. Thank you.
Go ahead. Go ahead to number 4. All right, we have a fourth and final case on our docket today. It's Josephat versus Palm Beach County School District, 20-3418. And we have a situation in which counsel for appellant has not appeared. What we have decided to do in this situation is that, given that counsel for appellee has traveled quite a distance, I believe, to be here and to present an argument on behalf of our client, we're going to allow that to happen. So you do have 20 minutes. We would welcome you to use all 20, or is something less than that. We apologize for the situation here, but you get the podium all to yourself. So please proceed.
Thank you, Your Honor. This is somewhat unusual. I'll just, I guess, hit the high points of my argument, and if the court has any questions, I'm happy to answer them. In this case, the JCC correctly denied fees and costs to the claimant because the employer carrier indisputably never denied the request for orthotics, or nor did the employer carrier fail to furnish them within a reasonable time. Opposing counsel, in her initial brief, recognizes that this issue is determined by the court under a competent substantial evidence standard of review, but in the brief, she does not actually specify any particular fact that she feels was ignored or not recognized by the JCC as an error. Under the circumstances, since it is undisputed that the carrier did everything required within the requisite 30 days and never, ever denied the orthotic claim, we submit that the competent substantial evidence in this case squarely supports the JCC's ruling that the claimant's counsel was not entitled to attorney's fees and costs.
Well, if you could help us with the timeline. I guess the petition for benefits was filed on November 6th of 2019 is what I have. And the claimant ultimately receives the orthotics in February of 2020. So if you could focus in and tell us what you see as the 30-day window. What's the 30-day, what's the starting point and the any point for the 30 days that you think is the one in which your client provided? It wasn't, I don't think it's so much a denial case, it's whether it was provided, the orthotic.
Yes, the petition for benefits was filed November 6th of 2019.
Okay.
On November 11th, 5 days later, the adjuster emailed a referral for the orthotics to a provider called SMS. On November 26, 2019, the carrier filed a response to the petition for benefits saying that the carrier had already authorized the orthotics that were the subject of the petition. The response also stated that the provider, SMS, had been trying unsuccessfully to reach the claimant. Ultimately, on December 5th, 2019, SMS did make contact with the claimant. On December 13th, 2019, the claimant was fitted for the orthotics by Falk, who was, I guess, the manufacturer of the orthotics. And then there was a dispute as to precisely what it was that Dr. Francisco had requested. It was the employer carrier's understanding, and it turned out to be true, that Dr. Francisco had only requested some basic orthotics, the things you put into the shoes. Falk actually had decided unilaterally that the term orthotics was ambiguous and ultimately fitted the claimant for something that was nowhere near what Dr. Francisco had authorized. It was basically a boot that they indicated would cost $1,600. Ultimately, the employer carrier did clarify with Dr. Francisco's office that he wanted simple orthotics, and rather than go back to Falk, which would have taken 4 to 6 weeks, the testimony said, the carrier agreed to actually get the orthotics from Dr. Francisco himself. The claimant was fitted with the orthotics on January 28th, 2020, and she received her orthotics on February 21st, 2020. So at no point in time did the carrier ever deny authorization, and contrary to the appellant's arguments, there is nothing in this record that shows some unreasonable amount of time that it took to get the orthotics. Under the circumstances, we submit that the JCC's order denying attorney fees and costs.
So when do the 30 days start to run?
November 6, 2019, the date of the petition for benefits.
Okay, so within 30 days, there has to be what? Just an authorization but not a provision?
Correct.
Or just an authorization?
Under the case law, yes, just the authorization.
Okay, so if they authorize it, but the claimant doesn't get it for 6 months, they've met the employer's met their responsibility.
Correct. I mean, under the circumstances, in this particular case, there's nothing that the employer carrier could have done. This is something that has to be fitted and manufactured. This is not something that there was some kind of delay occasioned by the employer carrier's actions or inactions.
But didn't the employer kind of change course and saying, well, we're not going to get the orthotics from Falk, we're going to go with Francisco's company, Athletic Orthopedics? Wasn't that a unilateral decision?
It was a unilateral decision. As it turned out, and I believe the adjuster returned from vacation on January 3rd, and Falk had asked her to get with Dr. Francisco's office to be more specific on the prescription for orthotics, and when she was on the phone with them, she simply asked, well, what would you charge for the same thing? And Dr. Francisco's charge was cheaper. It was the same exact orthotic, and as it turns out, Dr. Francisco was able to provide the orthotic within 3 weeks after Falk had indicated it would take 4 to 6 weeks. So while the employer carrier did switch to Dr. Francisco, there was no delay occasioned by that switch.
Isn't the question limited to whether A, B, C, or D is met under the statute?
Correct, yes.
And so A, of course, it's not a question of medical benefits here. B, I think you already said the employer never filed a response denying benefits, right?
Yes.
Okay. And then C, there's not a denial of an accident, right?
No.
Okay. And then D, 440.24 and 440.28 are not applicable, and we're not dealing with that.
Correct.
Don't we stop there? So if A, B, C, or D is not met, that's the end of the story. You don't even get to the question of when attorney's fees attaches, because we're not even talking about attorney's fees.
I entirely agree. There was some language, and I think it's in the, I'm not 100% sure, but I think it was in the Sansone case where the court said, this is not a situation where it was an unreasonable delay. So the JCC, in evaluating this and entering her final order did address that and specifically found that based on what is essentially the undisputed facts in the case, found that there wasn't an unreasonable delay. So, yes, Your Honor, I agree that we should stop there, but in the event that the panel disagrees and indicates that under its prior case law, the court, the JCC could have or should have considered unreasonable delay as maybe tantamount to a denial of authorization. There wasn't even that. So, again, we submit that on this record, the JCC must be affirmed in her denial of the attorney's fees and costs.
Well, assuming there is an argument as to reasonable time, I assume it's your position that, well, one JCC may have said this was reasonable, another might have said it's unreasonable, but it's within a range of acceptability, is
Yes.
your argument.
Yes.
Because, I mean theoretically, an EC can always keep putting it off, but I would find it even cheaper. Oh, we looked at it, we got it ever cheaper. And, 6, 9 months later, the person doesn't have their orthotic. That wouldn't be reasonable. But you're saying, here, what you're saying is that under these specific facts, because the employer carrier acted in a reasonably timely way when they found an alternative provider, that's acceptable.
That's absolutely correct. I certainly would make any kind of blanket statement that an employer carrier can basically shop it around however long it wants. Under this particular set of circumstances, there's no question that it had absolutely no effect on the claimant's receipt of the orthotics.
There appeared to be some delay that may have been attributed to the claimant, but it looked like that was end of November, early December, maybe during the holiday period where they were having difficulty connecting.
Yes, it was actually somewhat earlier than that, I think. As it turns out, there was an issue with the claimant's phone number, and I went back and I looked at it very carefully. The employer carrier had the correct phone number. It was an 8606 number. And at the final hearing, the claimant testified that was, in fact, her number. The alternate number that was on the petition for benefits when the employer carrier went back to see if there was an alternative number was the claimant's nephew's phone number. And once we had that phone number, it was within a day that Falk was able to make contact with the nephew and to ultimately schedule the claimant for a fitting. But that was certainly not an error on the part of the employer carrier. I would also note that Falk also sent an email and a letter by U.S. Postal Service, and the claimant testified that she had gotten neither. So I'm not sure what else could have been done under the circumstances.
What other mechanism would be, let's assume the employer carrier is engaging in bad behavior in some way, was actually willfully delaying this over and over again, denying her a benefit. Does she have an avenue of what type of remedies could she seek in that type of scenario?
Well, I think under the Sansone case, I guess the argument could be made, that the claimant would be entitled to fees, penalties, interest, et cetera.
Well, I mean, but that turns at least the fee provision that we're dealing with here into a punitive measure. Mm-hmm. I'm not sure that that's the case. Are you saying that the only mechanism that she has to get a more timely response is to threaten you are now on the hook for attorney's fees?
Well, in the scope, well, there are sanctions available as well.
Through the JCC, right? I mean,
with the JCC.
She could go back to the JCC and
right.
say this employer is
acting in bad
around
faith
and not getting me my orthotics.
Correct, yes. So sanctions are available under those circumstances. And in extreme.
Including attorney's fees.
Including attorney's fees, correct.
But that's not this
That's
provision.
not this, no. And in fact.
And it's not this statute either.
It's not in statute. And there's never been any real argument that the carrier, purposefully delayed this.
Not suggesting
Yeah.
that's the case. I'm trying to
Right.
tease out sort of the parameters of this application, this particular statute, in the face of, potentially, if the employer was acting in bad faith, if there's another mechanism by which the claimant could seek relief to ward that off.
No, I think there is one outside the scope of the statute, but that's not before the court today. If there are no further questions, we'll rest on our brief and request that the court affirm.
Appreciate it, counsel. On behalf of the panel, I would ask that you keep track of your travel records for this case.
I will. Thank you,
you.
Judge.
We will be in recess.
All rise.